Well, you would have to issue court proceedings within 3 years of the negligent event or your date of knowledge of negligence by an identified defendant causing significant injury. It would be different if you're a child or a patient, and there are technical rules that apply to that, but a child will have until age 21. Well, there's a range of symptoms and signs that a GP, for example, should be aware of. They're aware of what we call red flag symptoms. The main ones would be bladder and bowel disturbance, saddle numbness, and pain in both legs. So they're neurological signs. Effectively, it costs you nothing. We would investigate the claim, take it on a no-win, no-fee basis under a conditional fee agreement. If the claim fails, you would pay nothing. If the claim succeeds, you would have to pay a success fee to my firm, but that's capped at a maximum of 25% of the claim for injury and past losses. But these sorts of claims tend to have a lot of value in the future claims, and you would get to keep 100% of those. Establishing a claim is reliant on expert medical evidence, so we would gather your GP and hospital records. We would need to instruct probably a GP and a consultant neurosurgeon to deal with breach of duty, and then a range of other experts to deal with the effect it's had on you, the condition and prognosis. Well, I'd establish whether or not you have a case based really on the chronology of events. I would need to look at what symptoms you developed when, what your presentation was to, for example, a GP or a hospital clinician, and then what action that they took in consequence. So I'm looking for red flag symptoms of Cauda Equina, and then an emergency referral for appropriate investigation, which would be an MRI, and then surgery within 24 hours, possibly 48 hours, but some would say 24 hours. It's very unlikely the case would go to a trial. Well over 99% of cases settle before trial. So we would need to gather your GP and hospital records. I would prepare a chronology of events. We would need expert medical evidence from a GP if you're bringing a GP claim. We would definitely need a consultant neurosurgeon, and we've got access to one of the leading experts in the country as a consultant neuro and spinal surgeon. We would need a urologist, probably a psychiatrist, an occupational therapist, possibly an orthopedic surgeon, and maybe a range of others. So it's you need a lot of expert medical evidence in this type of case. So come to Coles Miller because let me take the problem away from you. We know what we're doing. I'm experienced in these types of claims. We've got access to one of the leading experts, if not the leading expert in the country. Very good barrister that I'm on close terms with. We've run several of these claims together. I can take you through all of the steps, and it's really a question of me taking the problem away from you and looking after you. I know what these claims are like. The symptoms are dreadful. It's life-changing. I know all the different areas that need addressing. I know all the expert evidence that I need, and right at the outset, I can see the whole case. I know the plan that I have to follow. It just comes with experience. Even if you don't come to Coles Miller, go to someone that's experienced in these types of claims because they're very particular. Well, it won't cost you anything in that I would take the claim on a no-win, no-fee basis. What I would like a client to do is contact me and just run through the symptoms with me. Ideally, I need a chronology of events, what symptoms you developed over time, and just come and see me or call me or send me an email. All that would be free. I would assess the case on that basis and decide whether the claimant has sufficient prospects, and then we go through the next stages of getting in your medical records and then expert medical evidence further down the line. But we would take it on a no-win, no-fee basis. It is free. The only payment would be if the claim succeeds, you pay a success fee, but that's capped at 25% of your claim for injury, and any past losses. You get to keep 100% of your future losses, and that's likely to be a very major element of the claim with this sort of case. Medical negligence would be the failure of a clinician to reach a standard that a responsible body of medical opinion would say was satisfactory. You would make a claim for damages for medical negligence within 3 years of the negligent event or your later date of knowledge. And date of knowledge is broadly when you first became aware of negligence by an identified defendant causing significant injury, and that could be sometime further down the line. You would suspect you have a case because of your adverse symptoms, but that's not necessarily an indication there's been negligence. I would have to assess whether there's been a breach of duty, which is a failure to reach an acceptable standard when judged by a responsible body of medical opinion in that particular field. So if it's a GP claim, I would need a report from an expert GP. If it was an orthopaedic injury, I would need to get a consultant orthopaedic surgeon, an equivalent expert. There's always a consent process before you have medical treatment, but that doesn't absolve the clinician from failing to reach an acceptable standard, and it doesn't prevent you from making a claim. Generally, these claims take 2, maybe 3 years to reach a conclusion. They do take a long time because you need to gather the medical records and expert medical evidence, and you've got to establish breach of duty and causation of additional injury. So there could be a whole raft of expert medical evidence that you need. So 2 to 3 years is a reasonable estimate. These claims are often to do with life-changing events. We deal with these claims all the time. We've got a very good team here, very understanding people, and we form very good relationships with our clients. It's hard to generalise. They are difficult claims because you're trying to establish that a professional has fallen below an acceptable standard. So the courts will need convincing about that. These aren't easy claims. It's based on expert medical evidence. So it's settled over time, usually by offer and counter offer, formerly known as a Part 36 offers. But in the larger cases, I find that we have a round table meeting. So I would go perhaps to London, meet with my barrister and the opponent's barrister, and we get round a table and hammer out a settlement. So you prove medical negligence by obtaining the appropriate expert medical evidence. It has to be supported by an expert in that particular field. So if you were claiming about orthopaedic injuries or the failure of an orthopaedic surgeon to treat you properly, say an operation has gone wrong, you'd need a report from a consultant orthopaedic surgeon to establish that treatment failed to reach the appropriate standard. These claims very rarely reach trial. I've been running these claims for many years. I've only had 2 claims go to trial. So well over 99% of cases settle before trial. I'd say Coles Bill is a sort of kind, caring outfit. It's not a huge practice. It's a big, West Country firm, long established, and we look after our clients. There's a very personal relationship. We've built up a very good team. We've got access to counsel we've used very regularly, and a panel of experts that we use all the time. We've built up very good relationships.